Before ever getting to trial, the defense lawyer made a request to the judge to throw out this medical malpractice case. And you know what? The judge agreed to dismiss it. Why? Among other things, it's because the paperwork submitted by the expert on behalf of the injured patient was not in the correct format. You want to know what this is all about? Come join me for a procedural discussion, an important one, about this particular medical malpractice case that was dismissed all because the paperwork submitted to oppose this motion for summary judgment was not in the correct format. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. What's happening here is that an injured patient brought a medical malpractice lawsuit against a careless doctor, claiming that he was in fact negligent, that he was careless, and caused significant harm and injury. They have a medical expert to support their claims that they have a valid and meritorious case. The defense didn't think so. After this injured patient went ahead and notified the court that their case was ready for trial, they put the case on the trial calendar. The defense attorney went ahead to try as a last-ditch effort to get their case thrown out. And that's known as making a motion for summary judgment. And now it's basically having a trial, except it's being done on papers. Now the defense has to go ahead and submit all the papers that they believe will establish that there is no valid case. And they do that by submitting to the court the deposition testimony, pretrial testimony by the various parties in the case, the doctors, the hospital staff, the injured patient, now the medical records, as well as an expert affirmation. An expert must support this request. Now, what happens then? When they go ahead and ask the court to go ahead and dismiss the case with all of this evidence and testimony and proof, now the plaintiff's attorney, the injured patient's attorney, has to go ahead and now oppose this request. And how do they do that? They do that by offering all of the testimony and evidence that is favorable to them. They now have to have various medical experts to support their claim that yes, there is a valid and meritorious case. This motion for summary judgment and opposing it is extremely time-intensive for the attorneys involved. It can often take not just weeks, but many months, literally hundreds and hundreds of hours, to put together all the paperwork to submit to the court to establish that there are significant and material questions of fact that have to be decided by a jury and not issues of law to be decided by the court. So why is that important? It's because when the defense asks the court to throw your case out, they are basically saying, look, judge, there are no questions of fact. Instead, there are only issues of law to be decided by the judge. If, in fact, there are issues of fact, that's weird. If there are issues of fact, now, ultimately, their request will be denied and your case will go to trial and a jury will have to decide whether you are slightly more likely right than wrong in what you are claiming is true. Now it will be up to a jury. The jury decides questions of fact. Who is more believable? Which expert do they believe is correct? And that will be for a jury to decide. But during a motion for summary judgment, that does not happen. So now, here's the scenario. The defense goes ahead and asks the court to dismiss the case, not a case I'm involved in, but it was reported. And now the plaintiff, the injured patient's attorney, goes ahead and opposes this. And they do that by submitting all the evidence and all the paperwork, as well as an expert affirmation. Now, an expert is basically saying, I have reviewed all of these records, and it is my expert opinion, based upon my experience, my knowledge, my expertise, that the following departures occurred. And as a result of these departures from the standard of care, this patient sustained the following terrible injuries. And now, the defense expert says something totally opposite, that everything was done correctly and the patient didn't suffer any injuries because of what we did. And the plaintiff's attorney and their experts say, hey, look, our expert says just the opposite. In that instance, now, the court typically will say, look, I can't determine which expert is correct. So that means that there are questions of fact to be decided by a jury, and if true, now I'm going to deny the defense's request, and this case will proceed to trial and let a jury decide who's more likely right than wrong. So before I get to the ultimate conclusion of what actually occurred here and why, you have to know something else. There was a recent change in the court rules that said when an attorney submits an expert's document, an expert's affirmation to the court, there needs to be certain language in there. There has to be an acknowledgement by the doctor recognizing that this document is going to be used in a court of law. and that he swears that these things are true to the best of his knowledge. And there's other specific language. I'm not using the exact verbiage, the exact wording here right now, but there has been a change in that particular format for submitting these expert documents to the court. And now when the court evaluates all of these papers submitted by the defense, and then they evaluate all the papers submitted by the plaintiff, in this particular reported case, the judge basically focused on two important points as reasons why the court was dismissing this patient's case. And the first one I'm not going to get into because it's not relevant to this particular topic. The second important point that I'm making here is the court pointed out that the format in which this particular expert submitted this document through their attorney, through the patient's attorney, was not in the correct format. It did not have the correct language that now is required, according to the court rules, that says you now have to have this particular language in there saying that the doctor is aware that this can be used in a court of law for various purposes, and they acknowledge and affirm this. Because that language was not included, the court made a point of establishing that because the plaintiff's attorney did not use that new language in that expert affirmation, this court, this judge, was now dismissing this patient's case. Now there's something interesting you should know. The statute, the law in New York, as it currently reads, does not require that specific language. However, the court rule does say and does recommend that this new language be adopted and incorporated in these expert affirmations. What does that mean? It means to me, in my opinion, that there is now a conflict between what the statute requires and what the court rule requires. And in this instance where now the judge has gone ahead and dismissed this patient's case, now it may raise the opportunity for that injured patient's attorney, that plaintiff's attorney, to go ahead and appeal that issue. So you might think, okay, if they appeal that issue and they are successful, does that mean that the case will be restored and continue on to trial? No, actually not in this case. Why? Because there was another key reason why the judge dismissed this case. So even if this procedural issue was not involved at all, according to this reported decision, this patient's case would still have been dismissed. So why do I share this information with you? I share it with you because so many patients, so many injured victims focus on the merits of their case as they correctly should. They have to understand and you have to recognize that there's so many procedural issues that go on behind the scenes that you oftentimes do not hear about and don't learn about until something like this occurs, where now a judge makes a decision based upon a simple procedural error or a simple procedural mistake made by one side or the other. And now the question is, can that be corrected? You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.